I'm going to ask you some general questions now about how the panel approached appeals, and then I'm going to come on to ask you some questions about particular cohorts of appeals. Firstly, what was your understanding of the risk of being infected with hepatitis C via a factor blood product?
I know that Dr. Ramsey, in her report, I think it's on page 3, said that in, I think it was 1980 to 1990, 1 unit in 200 of blood was infected with HCV.
So that, yes.
I'm sorry, 1 in 200. I said 1 in 100. I think it's 1 in 200.
So your understanding of the risk of being infected with hepatitis C from blood transfusion came from Dr. Ramsey's report, did it?
Well, Dr. Hewitt would have talked in general terms about the history of infectivity of blood with hepatitis C. But when we, as I said before, when we tried to get some quantitative data from Dr. Ramsey, she quoted 1 in 200 units of blood being infected with hepatitis C in a quite a late decade for the lifetime of this panel. Well, sorry, not the panel. The cut-off date was 1991. So for the 10 years before that, when presumably hepatitis C was at no lower than it was in earlier years, it was said to be 1 in 200.
We've heard evidence from various witnesses in relation to the risk of being infected with hepatitis C via a blood product such as factor 8 or factor 9 being 100%. Was that the view that the panel took?
I'm sure it was, but in a sense it didn't matter what view we took, because there were no cases coming to us, because all the people who had clotting factors were automatically allowed, their applications were granted. So we didn't have any, I had factor 8, but I'd been refused appeals because there weren't any.
Did you have any appeals where people had or said that they'd had cryoprecipitate?
Not that I can remember. And again, I this wasn't something I looked into closely because it didn't affect us, but I have a recollection, which may or may not be right, that cryo was counted as a clotting factor, therefore the stage 1 applications were being granted. I may be wrong about that, I don't know.
How did you assess the balance of probabilities as a matter of generality when you were determining appeals?
Well, it's an extremely difficult issue, isn't it? Because it's clear that that's the standard the department set. It must be probable that the infection came from blood or blood products, but for our purposes, really blood. Was it more likely than not? Now, what we did do, we made a sort of major presumption in favour of appellants, which was that if they had a transfusion, we made the assumption against the arithmetic that it was infected. If Dr. Ramsey is right, and I have no way of knowing whether she is or not, only 1 in 200 units of blood transfused to appellants would have been infected with hepatitis C. But we ignored that. We thought, we don't want to make it too difficult. We will assume that anybody who has had a transfusion, unless there's a blood transfusion, unless there's a countervailing factor such as intravenous drug use, we will assume that that blood unit was infective. We could see when we started work that the Skipton Fund took a rather literal approach. If there was no record of a transfusion, then that was it. Application refused. We thought it couldn't be right for us simply to do that because it would make the whole appeal process pointless if we simply followed the Skipton approach. And I thought it was legitimate, and we discussed this and we agreed that one could look at inferences. One could say there's no proof as such that appellant X had a transfusion, but looking at the overall context of medical history, availability of records, outcomes, strength of recollective evidence, we think in some cases that one can say, hand on heart, it is probable that there was a transfusion, and then we, at that stage, our presumption in favour of the appellant kicks in, and we will not say, but we still have to find out whether that was an infective unit or not. We will assume it was, and we will allow the appeal. I don't know what the right time to be was, just a matter of context, because at the very helpful note that Council produced on the Skipton Fund on this area, I think from memory there were 6,700 odd applications to the fund, and there were 433 appeals, which is, I think, about 6.5%. 300 of those were cases of variously described as medical records or lack of information. And of those, they're by, I think, common consent, they are the most difficult cases. We allowed 60% of those, round numbers. So 300, we approved 180 and we refused 120. So that, and I noted at the end of, well, in his witness statement and at the end of his evidence, Professor Thomas, who Professor Mills said was the foremost authority on hepatitis C, certainly in the UK, possibly in the world, he describes them as difficult decisions. And if we can later, I'd like, because I looked up the transcript last night, there are 2 passages where he deals with the inferential process, and I think what he says is very interesting indeed. But I'll leave it to you when you want to do that. So what we got was as much information as we could, and then we said, now on the basis of all this taken together, do we think it's probable, not possible, but probable, which is our criterion, that there was a transfusion, in which case we'll assume it was the cause of the infection.
The application form already included a statement from the clinician to say that they thought that the blood transfusion or a blood transfusion was the probable cause and that there were no other risk factors. Why was that not enough, given the fact that they had assessed the patient and the appeal panel was not in a position to do that?
We thought our obligation was to take a fresh view because as in the same way as we didn't want to just say Skipton Fund said no evidence, therefore we'll refuse the appeal. If the Department of Health had wanted a scheme where the certification of the clinician was conclusive, it would have said so.
Did the qualification...
So may I add as well that in of the 300 cases that came to us, and particularly of the 120 that we refused on those grounds, the information from the clinician was often much more equivocal than, yes, I confirm it's the only cause. And I can't give you examples off the top of my head, but if one trawled through those 120 cases, I'd be very surprised indeed if all 120 had certificates from the clinician, yes, there was a transfusion. Quite often you see things like patient says transfusion such and such.
So clearly if the certificate is equivocal, then that's something that the panel would have taken into account. Is that correct?
Yes.
If the certificate is yes, it's my view that the probable cause of the hepatitis C was the identified blood transfusion. What weight did the panel give to that?
It gave it considerable weight, but it didn't of itself push us over the balance of probabilities. but really for the reason that I've just said, that if that's what the department had wanted, a certificate from a clinician equals a payment. That's what it could have had, but it didn't choose that.
And did the qualifications and experience of the clinician filling out the form make any difference to the amount of weight given to it by the panel?
I honestly can't remember the answer to that. There certainly wasn't a system where, he's a professor or she's a professor, we'll accept that, or she's a junior doctor in the back and beyond, we won't accept that. There was nothing like that.
Would not a straightforward application of the burden of proof on the balance of probabilities mean that unless you had a reason to think that the clinician was wrong, you could approve the application?
I don't think so.
I'm going to ask you some questions then about natural clearers.
So before you go on to that, I was sent a decision from a HIV panel by Bennett Heitner QC, and I was told that was because the approach there was the least unlikely. And do we think about using that? Do you want to deal with that, or do you want to?
Yes, I'll come on to deal with that in a little bit later on this morning. I'm going to ask you some questions about natural clearers. Was the test for determining whether someone had cleared hepatitis C within 6 months determined on the balance of probabilities?
Yes, it was, but it was really determined on PCR tests, the results of PCR tests, as I remember it. In other words, if there is evidence that there is a positive PCR test after 6 months, we would just allow it straight up.
What did the panel do where there was evidence that the person had cleared hepatitis C, but no evidence as to when it had been cleared? In other words, the PCR test was not taken until several years after the infection was identified.
You mean a positive test or a negative test?
So negative test, yeah.
Well, I think at that stage we fell back on the general epidemiological data, which suggested, I can't remember the proportion, but a very, very high proportion of people who cleared it in the first 6 months, which was presumably why the department put that criterion in the scheme. And therefore, if the burden is to show it's more likely than not, and say 95%, I'm picking a number out of the air, but of that order, if they clear it within 6 months, there's a 1 in 20 chance that this person didn't.
Did the panel ever consider an alternative approach, namely that on the evidence before it, it was only possible to conclude that the applicant had cleared the virus at the point the PCR test was negative, i.e. it was only safe to conclude that the person had cleared the virus on that date?
I don't think so, for the reason that I've just articulated, but these were relatively unusual cases for us. They weren't the sort of the main diet of the panel, and in general we resolved ambiguities like that on terms of what was, according to the advice of the accepted view, was 95% likely, which was it had cleared, if at all, within 6 months.
I'm going to ask some questions now about anti-D, immunoglobulin.
Yes.
You say in your witness statement that the panel had a settled view on the chances of being infected with anti-D as a result of the advice from Dr. Hewitt. Can we look at SKIP 5031_071? This is a letter dated 24th of February 2005 to Mr. Keith Foster from the scheme administrator. Can we go over to the second page, please? We see there it's signed by Dr. Patricia Hewitt. Can we go back to the first page? Is this a document that the appeal panel had? Do you recall?
I honestly don't remember. I know there are 2 letters. I know that Patricia Hewitt wrote another one with a co-signatory, and I think, but I'll be corrected, that was in response to a request for a sort of a template from Nick Fish. but the views were pretty much the same as recorded. I mean, I've read both these letters recently, preparing for today.
So
I can't remember whether I saw this letter. Of course, it was written long before the panel was convened.
So when you say in your witness statement that the panel had a settled view on advice from Dr. Hewitt, was that advice given during appeal panel meetings rather than written advice that the panel were aware of and understood to be her view?
in essence, yes. There was no doubt, I think, from her experience, her position, and indeed her reputation, that she was the person who knew most about this, and in the UK. And she made it perfectly clear that there were no recorded cases of hepatitis C infection caused by UK anti-D. And if that's the case, given the yellow card systems and the close community of haematology, and particularly, I can't think of the right word, the transmission of blood products and blood to patients, I think she was best placed to know. And Dr. Mutimer, all the other medical members never raised any, not any possible objection to her view. Now, have we seen somebody sometimes there were batch numbers which were confirmably UK product, sometimes not, but she says in either this letter or the other one that anybody who got Irish or German anti-D, it was only given on a named product basis, which would mean that the records would be very likely to reflect the fact that this was a specially authorised treatment. And we never saw one.
Was this the panel's understanding from Dr. Hewitt that intramuscular anti-D that had been manufactured in the UK had an unparalleled safety record?
Well, that's a normative judgment, isn't it? What we accepted was that there were no records of intramuscular NHS or UK-derived anti-D had ever been recorded to have caused hepatitis in a patient.
But and did the panel also accept that there were cases of infections from anti-D where they were manufactured outside the UK and imported, and provided on an IV basis, on an IV basis?
Well, I'm not sure what you mean. We knew that there were certainly that the Irish product was imported. I see now at the bottom of this page, Dr. Hewitt says, "I'm not aware that the product used in Germany was ever imported to the UK." I'm in no position to agree or disagree with that. I simply don't know. But the position on the ground was that there was never any evidence that anti-D treatment was with anything but UK product, and there was no evidence that UK product had ever infected a patient with hepatitis. I'm sorry, there are a lot of negatives in there, but the short answer is we did not believe that anti-D carried a risk, let alone a balance of probability risk.
Shemit, you can take that document down. Was it possible to know when you saw an appellant's records what kind of anti-D had been given?
I think you'd be far safer asking Dr. Hewitt that question. Certainly, I never remember seeing something saying Irish product, name, patient basis, anything like that.
Do you recall?
And sorry, but just to finish the answer, and in some, but not all of the cases, the batch number of the anti-D was written in the notes, and Dr. Hewitt said, and I was in no position to contradict her, that is UK product.
So is this fair that some of the appeals, it was possible to identify conclusively from the records that the anti-D was a British product, but for some of the appeals that information wasn't available?
And some of the appeals, it was not, well, I was not in a position to identify the batch number or the source of the product. And at that point, excuse me, Dr. Hewitt, uncontroverted by other medical members of the panel, asserted that this was anti-D and that there was no risk of hepatitis. That's the best I can do, I'm afraid.
I've shown you the 24th of February 2005 letter from Dr. Hewitt, and you've mentioned that there's another later letter from July 2010. Were those letters ever provided to applicants as part of the decision process to help them understand the basis for the
we didn't send out, attached to this decision is a copy of Dr. Hewitt's letter.
Do you think it would have been a good idea to do so in the interests of transparency and fairness to the applicant, so they could understand the basis on which their application had not succeeded? Potentially,
but we were in a position where, as I mentioned before the break, we had agreed, rightly or wrongly, with the fund that we would send out short, concise letters, and we were. I mean, I could have written judgments, but I wasn't encouraged to or asked to. In which case, one would set out, as in a normal court or tribunal judgment, evidence relied upon.
And did you have any concerns that?
I'm sorry, may I add to that?
Yes.
We also put the basis of the decision in the guidance notes for the applicant.
Did you have any concerns that as Dr. Hewitt was the only member of the appeal panel who had expertise in this area, she was effectively assessing the value of her own expert opinion?
Well, theoretically, yes, but we've heard that the department was very hard pushed to get a haematologist onto the panel. I'm not suggesting this makes it all perfectly okay, but Dr. Hewitt was and is a well-recognised expert on the subject. She was, in my view, entirely neutral and very fact rather than value-based in her judgments on appeals. I didn't think we had a better source of opinion. I can see in one sense it's not transparent, but it seemed to me that it was what we had was most likely to lead to both a truthful and a fair outcome.
Do you recall having any appeals about gamma globulin?
No. I mean, I knew all about that because 1995, just as I was leaving private practice, there was a gamma globulin. I think 2 batches were imported. It was made by Baxter Healthcare in the United States. And 2 of the batches had hepatitis C in them. And I negotiated settlements on behalf of those who were infected with Baxter and their lawyers. So I knew about it. It was intravenous as far as I remember. And there was no doubt whatsoever that these batches were infected with hepatitis. I even oddly remember why it was infected through the manufacturing process, and that they had no defence under the Consumer Protection Act because the FDA in America had forced them to use a particular manufacturing process as the price of getting a product license. And it was, so they weren't, the company wasn't protected by a national or an EU requirement, which would have been a defence under the Act. But they couldn't avail themselves of that. I mean, I remember the case very well. But there weren't any, we didn't have any gamma globulin cases.
I'm going to move on now to intravenous drug use. Can we look at the Dr. Ramsey report? It's SKIP 5031_217. So you've explained in your witness statement how this came about, that the members of the appeal panel had a hunch, I think you put it slightly stronger than that the risk of being infected by hepatitis C was higher for an intravenous drug user than it was for somebody who'd received a blood transfusion.
Yeah. So may I interrupt you? I used the word hunch, but it was more than that. The received wisdom, if you like, was not by me because I wasn't a doctor, but the fund, whoever trained Nick Fish, trained him that IVDU was in principle far more likely than the blood transfusion to infect somebody with hepatitis C. The 3 doctors on our panel were clearly of the same view. So it wasn't a hunch in the sense of a guess. It was a received wisdom. But I thought, rather than say it's a received wisdom, it would be fairer to appellants if we tried to quantify their relative risks.
And the purpose of obtaining this report was to do precisely that. Is that
Yeah.
correct? Can we go over to page 2 of the report? Third paragraph down, she set out what her model is. She says, using this model, it's not possible to estimate the risk of infecting, I think she must mean infection, for periods of less than 1 year. But this does suggest that over recent years, about 16% of injectors in England and Wales acquire HCV infection in the first year of injecting. And then she goes on to say, data suggests that most injectors are initiated or assisted by friends, and that amongst those who initiate others into injecting, sharing of needles and syringes and of paraphernalia is more common than amongst those who have not initiated others. Did you take from this that the history of how the person started to take intravenous drugs was important?
I thought it was a factor to be considered, yes.
And then in the next paragraph, about halfway down that paragraph, she says the risk of transmission from a single episode of syringe sharing with an individual with chronic HCV infection was estimated to be around between 1.6 and 4.3%. And then skipping the next sentence, assuming that susceptible individuals share randomly with injecting drug users in this population, this would generate a risk of between 0.4% and 1.5% per single sharing episode for intravenous drug users in London in 2002 and 2003. And then she goes on at the bottom of that page to say, in that last paragraph there, talking about additional factors that influence the risk, she says that the prevalence in London and the northwest of England is particularly high and associated with high risks of transmission. And then over the page, at the bottom of the first paragraph, she talks about the temporal connection, that injecting drug use prior to 1990 is likely to be associated with even higher levels of HCV acquisition.
Yeah.
And then at the bottom of that page, in the last paragraph, in the middle of that paragraph, it is the part that you've already referred to, assuming that infection would follow receipt of all donations from HCV RNA positive donors. This would equate, she's talking about risk of transmission by blood transfusion. Assuming that infection would follow receipt of all donations from HCV RNA positive donors, this would equate to an approximate risk per transfused donation of around 0.05% in that period. Shamit, you can take that down now. Did you understand this report to exclude transfusion as a cause of hepatitis C where there was a history of intravenous drug use?
You can't exclude it absolutely, but we looked, on page 2, about 1 in 6 injectors acquire HCV infection in the first year of injecting. Now, amongst syringe sharing deniers, you halve that risk. So 1 in 12 people who deny sharing needles are infected. So about 8%, round numbers. Whereas about 0.5%, have I got that right? Yes, about 0.5%, no, about 0.05, so 1 in 200 or 2,000 get hepatitis C from transfusions. It seemed to, not just to me, because I wouldn't have, as it were, thought I had the best view on this, but the medical members on the panel said this is clear confirmation that if there are two competing causes, the probable cause is injecting even once, even denying sharing with an intravenous drug. The plain numbers, and I must admit that was immediately I don't claim expertise in the subject, but I've dealt with a fair amount of epidemiological studies over my career in litigation, and it said the same to me. But you're far more likely to get it from even one sharing, denying use of intravenous drugs than you are from a unit of blood. And of course, that doesn't mean the risk is nil, but it means it's not over 50%.
Did the panel consider the history of drug use versus the history of blood transfusion?
Yes.
And amend the percentages accordingly? So in other words, if there's one account of one intravenous drug event, and there is an account of multiple transfusions, would the panel have adjusted the percentages accordingly?
There was no such case. There was one case, certainly, where, in fact, I think probably the only, excuse me, the only appeal we had where there was a confirmed transfusion, but there was also IVDU. And we thought in that case, taking into account the account from the person herself, and if I remember rightly, members of the family, we thought if we applied the Ramsey figures to that, the analysis to that, it was still comfortably more likely that the hepatitis C infection was from drug use. Now, we may have been right, we may have been wrong, but it appeared to us if we had to say, was it probable that the infection came from hepatitis C, we had to say, no, it wasn't. It was possible, but it certainly wasn't probable. That was our reading of it.
In some, I wouldn't say many, but some of the cases, I wouldn't say many because I don't know if that's right, but some of the cases that the inquiry has looked at, there is a history given by the appellant that there was no sharing of equipment.
Yes.
Is it right to understand that in those cases where they were rejected by the panel, it was because the panel did not accept that account given by the appellant?
The last thing we wanted to do with any appellant who had the misfortune to be infected with hepatitis C was to make judgments about truth. We weren't equipped to make judgments about truth. We weighed in the balance, somebody saying, I used drugs, but I never shared needles, against the figures in the Ramsey report. The Ramsey report says half as many people are infected with hepatitis C from drug use who deny sharing needles as those who admit sharing needles. And the overall incidence is more than 10 times higher than the risk attached to hepatitis C. I think I'll go back to an earlier point. If we had had a system where there were complete records, there was first-hand evidence, the Skipton Fund, if it wanted to, was able to cross-examine the appellants and we could make a decision based on what we heard, that would have been one thing, but we didn't. We had a paper-based appeal, we had the, if you like, population statistics, we took into account what the appellant said, we didn't, as far as I remember in 433 appeals, we didn't ever suspect that anybody was lying to us.
Isn't, where there's no opportunity to test the evidence for precisely the reasons you give, wouldn't the fairest approach have been to have accepted that evidence about sharing of needles and so on at face value, unless of course there was objective material in the objective evidence in the material before the panel to suggest that wasn't the case? Wouldn't that have been the fairest approach?
You have to go back to the way the scheme was set up. There was a burden of probability. So I can't see in the face of those figures how one can... the Department of Health could have said, and on an appeal, any appellant who asserts that she didn't share needles shall have the benefit of the doubt. It could have said any of those things. It could have said where there's a possibility that the infection came from blood, the appellant is entitled to an award, but it didn't. I know that this has caused a great deal of unhappiness, but we perceived that we were applying the burden that the scheme was set up to administer.
Did the panel look at other evidence to try and work out whether the dates of the transfusion were consistent with the infection compared with the dates of the intravenous drug use? So, for example, progression to liver disease or matters of that nature, evidence of that kind.
I can't remember in particular. I mean, the truth was that after the Ramsay report was used and appeals were unsuccessful, the appeals, they didn't completely dry up, but they were very, very rare after, say, 2007, 2008. Now you might say that that's unfair too, but faced with the evidence we had, the case you put in the bundle is one of the most marginal cases, because we know for sure there was a transfusion, and we know for sure that there was a small amount of drug use. If I remember, and I may well be wrong, in which case I'll be corrected, that particular appellant said that she bought the drugs from a friend. Well, Dr. Ramsay says doing it with, or buying it from friends, doesn't say exact words, increases the risk of infection with hepatitis.
Isn't the risk of relying on the conclusions in Dr. Ramsay's report, which are of necessity at the general level, isn't the risk of that one ignores or overlooks or doesn't give appropriate weight to the actual evidence from the appellant that's in front of the panel?
Well, I think I'm going to repeat myself. We looked at the evidence from the appellant and any other witnesses. We gave it what weight the five of us together thought it should have, and we then contrasted it with the risks set out in the Ramsay report. And it's the classic case where, in our view, it failed on the balance of probabilities. I'm entirely open to the fact that in some cases we got it wrong. It would be a miracle if there were 433 cases and they were all decided correctly. But we did our best in what were very limited circumstances and with limited resources. I don't think I can say any more than that, I'm afraid.
You've seen the report that the inquiry's provided about its analysis of the Skipton Fund and the appeal panel's decision making. Is this right, that there were 48 appeals before the and I can take you to the pages if that would help, but 48 appeals where intravenous drug use was a factor. At 44 of those were refused, and the 4 that were allowed on the basis that the appellant had been wrongly accused of being an intravenous drug user, i.e. they succeeded because the appellant was not an intravenous drug user.
But I haven't reviewed these files. I'm very happy to accept that note is completely correct.
Does that not suggest that in fact the panel were treating the Ramsay report as meaning that it excluded transfusion as a risk, as the probable cause of hepatitis C, when an appellant has a history of intravenous drug use?
In most cases, we thought the risks documented in Dr. Ramsay's report far outweighed the risk of a hepatitis C transfusion. Now, I think I said before, but I'll repeat, there was only one case that I can remember, and I haven't reviewed these cases for today, where there was actual evidence for transfusion. So let alone was it a 1 in 200 or 1 in 2,000 risk if there was a transfusion of the unit being infected, there wasn't even a record of a transfusion. I mean, one can envisage a case where somebody, for medical reasons or for experiment or an academic study or something, somebody is given a single injection with intravenous drugs in a clinical or experimental surrounding, and it is clear that all the kit is completely virus-free, sterilised, and the drug is pure and has been obtained from a government laboratory or something, where one can see that there was nil risk of transmission of hepatitis. Those were not the cases we were dealing with.
What was the approach in relation to intranasal drug use? Did you have any appeals in relation to
No,
that?
I don't think. I mean, I think Ms. Richards in her presentation said, "What's that got to do with it?" And in fact, and I think the answer is, I wonder myself. I think the answer is that it was to do with sharing straws for snorting cocaine, but we never had any of those cases.
Was a copy of Dr. Ramsey's report provided to appellants?
No, for the same reason.
Do you think it would have been a good idea to do so in the interest of transparency and fairness, so they could understand why their appeal had been turned down?
In a different regime, yes, I would have. If I'd been writing a judgment such as I wrote for different tribunals, I would refer to the passages from Dr. Ramsey's report relied upon, or accepted by the panel. But that wasn't this situation, and it's a highly technical report. There wasn't. This is going to sound really weak. There was nothing to stop an appellant or an applicant turned down by the fund asking for it. I would have had absolutely no objection to anybody seeing it, but we didn't routinely send it out. Maybe we should have done, but we didn't.
And do you also think it would have been fairer to the appellant if the decision letters in these cohorts of cases had explained what conclusions the panel had come to about the appellant's own account of their drug use?
I mean, yes, in the sense that had we not assumed, rightly or wrongly, that what was intended and what I provided was a short form summary decision, yes, one could go into it. I was used to writing 20 pages of A4 judgments about medical cases in a different tribunal. It could have been done. Our belief, I should take responsibility myself, my belief was that wasn't what was required or intended. Again, I may be wrong, but that's the view we took.
I'm going to ask you some questions now about the largest cohort of appeals, as you've identified, with the lack of medical records cohort. You've described, we've touched on the clinical plausibility, and you've explained to us how that works. Was that something that the panel considered, both in cases where medical records were missing entirely and cases where there were medical records but they didn't show a record of a transfusion?
Yes.
And what were they used in most cases where there was a lack of medical records or a lack of a record of transfusion, or were they only used, was clinical plausibility a fallback position used where there was no evidence either way to suggest a transfusion, i.e. if there was a first-hand account from the appellant that there'd been a transfusion and supporting evidence from family members that there'd been a transfusion, would the panel still rely on clinical plausibility?
Yes, because, for example, somebody might say, I was in a road traffic accident and I broke my ankle, and I got hepatitis sometime afterwards, and I've been told there are no records. Yes, we would have said, well, now, is it probable that somebody on this limited information with a broken ankle would have had a transfusion? You see, from our point of view, the alternative really, if we're applying a balance of probabilities test, is just to say, well, hard luck. There's no evidence. And we were trying to be helpful when we did this. We were trying to say that the funders turned you down on the basis there is no proof, literal proof, a record of a transfusion. We must be here to do something a bit more than that. And that's how we'll approach it. And that's in some, and obviously the more records that existed, the more confident we could be that our leaning towards transfusion or not was in the right direction.
And how confident could the panel be about its conclusions on clinical plausibility, where, for example, the history is of a procedure that's out with anyone on the panel's expertise. So, for example, an orthopaedic procedure or a gynecological procedure or something of that nature. How confident could the panel be about the likelihood of requiring a blood transfusion for that procedure?
Well, there are 3 doctors who've had medical training. I think that you can ask Dr. Hewitt to confirm that she has had some experience of gynecological work. I'm not sure, but I seem to remember so. I may be wrong. Doctors would no doubt look at the leading medical textbooks. I mean, panel member doctors would, I'm sure, as I've said in my statement, inform themselves. I wouldn't, and Annie Hitchman wouldn't. We wouldn't sort of go on the internet and say, such and such gynecological procedure, what's the chance of a blood transfusion? That would really not be within our competence. But the doctors would express an opinion.
We heard...
May I just add that I think all these questions sort of end up in the same place. If we've been able to award a payment to somebody who had possibly had a transfusion, of 120 refusals that we actually made, certainly not all of them would have been awarded, because there were some where there were good records and there was clearly no transfusion. But I would have thought a majority of the 120, if the criterion, I'm sure, majority of the 120, if the criterion was a possibility or a reasonable possibility, or you get an award unless the fund can prove that you didn't have one, all those different counterfactual standards, many more of those 120 would have been, or of those 300 overall, it wouldn't have been 120 winning the appeal, it would be, I don't know, maybe 250. But we considered that the phrase balance of probabilities was there for a purpose.
So when we heard evidence yesterday from Professor Thomas that the approach that they took at the Skipton Fund to this was to look for evidence as to the likelihood of the blood transfusion being carried out for that particular procedure in the same way we've heard the appeal panel doing. And that if there was a less than 50% likelihood of the procedure requiring a blood transfusion, then the fund would consider it unlikely to have occurred. Is that the same approach that was taken by the appeal panel?
If we thought it was less than 50% likely that there had been a transfusion, we felt constrained by the obligation to deal with the case on the balance of probabilities. We would have felt constrained to turn down the appeal. What Professor Thomas says, I looked up the transcript last night, is in fact very interesting. I don't know if you're going to take us to the passages which are on page 161 and page 170 of the transcript respectively. But he says that, and effectively he says, well, if it was 20% likely, we'd have refused it and sent it to the panel. And then he then justifies this on the basis that the fund uses an objective standard and we use a subjective standard. Well, with the greatest respect to Professor Thomas, I don't find that anywhere in the agency agreement. We are surely operating the same standard, which is the balance of probabilities.
So,
while on the subject, I can't remember which page, that's 161 and 170, he says, these were terribly difficult cases. Well, I completely agree.
So would you accept that on the basis of the approach that Professor Thomas outlined, and which I think you've said was also the approach of the appeal panel on clinical plausibility, i.e. there had to be more than 51%, well, out of every 100 people that had a procedure, that particular procedure, if only 49 of them would have required a blood transfusion, i.e. there's a 49% chance of having the blood transfusion, then you don't make the burden of proof on clinical plausibility. Is that... You're looking like you don't agree with that.
Well, not that I don't agree with it. We didn't. I can see why you're putting it that way. We didn't say let's have 100 cases like this, because there would have been no factual basis for that. We said, now here we have somebody who says, no doubt honestly, that she recalls a blood transfusion in certain circumstances. We can't find any evidence of it in the papers. We can find peripheral evidence that suggests that she did/didn't have a transfusion. Given that we have to think it's more likely that she did than didn't, we allow or reject the appeal. We didn't do it on a sample of 100 basis. I accept that that's what 51% means, but but we didn't do it on a cohort basis. We did it because otherwise, partly we're not under attack, but it's been put to us that we didn't take enough account of the individual circumstances. Well, if we had said of 100 people, what would have happened? That would be diminishing the importance of the individual's testimony even further, which would have been highly undesirable and highly unfair on the appellant.
So is this right, that clinical plausibility was not assessed on a percentage basis, i.e. that the discussions the panel were having were not, well, this particular procedure has about a 20% or a 25% or a 40% chance of requiring a blood transfusion?
What we did was we looked at all the evidence supplied by the appellant. We looked at all the medical records. We looked at anything like the Ramsey report or Dr. Hewitt's report, and we said, well, here we have two conflicting versions. For this appellant to be given an award, we have to show that the positive to her version is more likely than the negative to her version. I don't think I can put it any other way than that.
How did the panel factor in accounts from the appellant about, for example, a history of significant blood loss or having to stay in hospital for a long period of time after what should have been a routine operation, or the operation going on for longer than it should have been, matters of that nature? How would those factual matters weighed in the balance as against a conclusion that the panel had reached that it was clinically implausible that the particular procedure required a blood transfusion?
Well, I have to resort to anecdotes here. I remember vividly one case where somebody said, I was gushing with blood, I bled for a long time, severe loss of blood, and then there's a record of blood loss in the notes, and it's less than 1 unit of transfused blood. Now, Dr. Hewitt, again, she may be right, she may be wrong, but in my view, she was likely to be right, said, you would never, ever give a transfusion to somebody who had lost less than a unit of blood. So, every time one has a nosebleed or cuts yourself in the garden or something, you think, oh my God, look at all that blood. But that's a perception which is real to the perceiver, but it's not necessarily, it's certainly not determinative of the need for a transfusion. So, and again, when somebody stays in hospital, we just didn't have that much information in most cases. So what was very helpful was a discharge note to the GP from the hospital, and where you say, arrived on such and such a day, procedure, prepared for surgery, routine procedure, no complications, discharged on the nth day, which was expected. There is no basis in that to suppose that things went in such a way that they required a transfusion. I keep saying that, a transfusion. We may have been right, we may have been wrong, but we were trying to use the evidence as it existed.
So in the example you gave, that's an example, isn't there, where there's objective evidence within the material before the panel which suggests that the first-hand account being given by the appellant is not all that it seems.
No, sorry, I'm not saying that at all. I'm saying that the appellant's perception that she lost loads and loads of blood is not borne out by the measurement taken by the hospital.
Yes.
Now, I mean, maybe the hospital measured it wrong, I don't know, but we're doing the best we can with what we've got. On the objective, on the evidence as we have it, it seems very unlikely in this example that somebody who'd lost less than a unit of blood would have been given a blood transfusion. Maybe exceptionally it did, but we're dealing with balance of probabilities.
But how could the panel consider and come to conclusions on the credibility of first-hand account evidence where there is no objective evidence to tell the panel one way or another, as there was in the example you gave, without having heard from the applicant or the witnesses?
We'd had to do the best we could. We'd say, well, here is an account by somebody we presume to be honest, telling her recollection to the best of her ability. But it seems to us unlikely, going to pretty much impossible that this could have happened in the way described. Oh, sorry, you're asking me about cases where there was no countervailing evidence, right? I don't think I can do any better than that. And don't forget, we approved 60% of these cases. We weren't turning them down left, right, and centre.
Can I put this example to you? If the appeal panel knew that a person had a particular operation which had, in respect of which 10 or 20% of patients would have required a transfusion, and the appellant said that he or she had had a blood transfusion, and there was no evidence of other causes of contracting hepatitis C, but that equally there was no record of the blood transfusion. What would the panel's view of that have been?
Probably the same as Professor Thomas's. If it's a 20% chance, it's not probable.
But
don't forget,
on what basis?
Evidence.
On what basis, though, could it be said that the blood transfusion was not the most likely cause? Because there was no other cause. No other probable cause had been identified.
But there was no evidence that a transfusion had taken place, let alone if there was, it was a 1 in 200 chance it was infected.
I thought you were actually being asked to look at the situation where the evidence is not just a 20% chance of this particular procedure having a transfusion, but where the applicant, him or herself, says that they had a transfusion. Now that was the scenario you were putting, wasn't it,
Yes,
Scott? So it's not just a question of the 10 or 20%. She could very well, or he could very well, be one of the 1 in 10 or 1 in 5. And what might make the difference is being put to you, is that he or she says, I did, and there is no evidence that there is any other source of hepatitis C, because that, of course, is the starting point. Someone has hepatitis, question, have they satisfied you on the burden of balance of probabilities that they got it from a qualifying cause?
Well, I mean, not a direct answer to the question. But Dr. Hewitt, I remember, and I'm sure you'll ask her about this, to the best of my recollection, she said that lots of people who haven't had blood transfusions have hepatitis C, and nobody ever really knows where it comes from. Now, that's obviously a paraphrase of what she said. I can only repeat that, well, I suppose it also depends on the reasoning process, because I think maybe it's going to be put to me that we should look for the least unlikely, and I will have something to say about that in due course. If we didn't go out of our way to say she is not telling the truth, because generally speaking, we didn't think it. But I mean, may I say post hoc ergo propter hoc? Unless there's some reasonably convincing evidence that a transfusion took place in the first place, the fact that somebody remembers it, we put in the balance. But in our view, it couldn't be conclusive. I mean, it couldn't be determinative, even on a balance of probabilities basis. And I can see I can see a view which says, if somebody says they've had a transfusion and they've got hepatitis, then it's for us, the fund, anybody else, to disprove it. But I don't think that's what the scheme asked us to do.
You asked me if I was going to ask you a question about the approach in the document from the HIV blood and tissue transfer scheme case, and I can take you to the document if that assists. But this is the moment when I'm going to ask you that question. Where there are a range of possible causes of hepatitis C infection, none of which are likely, either because they haven't been identified as risk factors for the particular appellant, or because of clinical plausibility, or for any of the reasons that we've been discussing this morning. Did the panel ever consider taking a different approach and considering, well, which one of these four possibilities is the least which one of these is the least unlikely?
We never articulated it in that way, And I've obviously thought quite a lot about this since seeing that decision by Bennett Heitner, an immensely distinguished lawyer, and obviously one takes his approach very seriously. But first of all, there are a number of very significant differences between that case and one of the cases that we would have had. There was a massive amount of information. There were purported recollections by the consultant in charge about the use of fresh frozen plasma. And there was a Dr. Regman from the Department of Health who went down to Swansea to look at all the data. There was quite intimate history about the quality of the marriage concerned, and there was enough for Mr. Heitner to make a deduction about the prospects of the wife of the marriage being unfaithful, having sex with other people who might have infected her. That is just miles away from the paradigm case that we dealt with, where there was the only thing that was certain was hepatitis C infection. And more than that, because I was curious, and I haven't looked at this area of the law for ages, but preparing for today, I looked up, to the extent I could without a law library, the proper approach in cases of competing causes. And the most authoritative decision I could find was Nullty against Milton Keynes Borough Council, decision of the Court of Appeal in 2013, which said precisely that one shouldn't do what Mr. Heitner did. I could read, it's only 2 little paragraphs. It says the Court of Appeal reiterated the principle in cases where there are competing explanations for a loss, in this case hepatitis C, that causation cannot be established only by a process of elimination, such that the least unlikely cause of a loss is identified. A claimant, in this case an appellant, must demonstrate that the particular version of events that they rely upon is more likely to have happened than not, in order for the civil standard of or burden of proof to be satisfied. Now, I'm not pretending for a second that I took the law reports into every panel meeting and referred to this or to any similar iteration of the principle that Nullty says is being reiterated. But the real, I mean, that's in a sense a sophistic answer. The fact was we didn't have such rich pickings of evidence as there was in the HIV case. I don't know anything about the way that panel was set up. I don't know if there was oral evidence. I don't know if there was advocacy. I just don't know anything about it. But the level of detail of evidence in that case was light years away from what we had in the cases that we turned down.
So I'm going to move on to another topic. I note it's almost 1 o'clock. I think I've got about another 15 minutes or so of questions, so I don't know whether now is an appropriate time for a lunch break.
Well, in that case, we'll have to have you back after 2, if that's all right. And 2 o'clock. So time for lunch now, and we'll start again at 2 o'clock.
Thank you.